discussion about the aftermath of the election or the Supreme Court's judgment that happened on the 8th governorship ruling. So last Friday, it defined the political career of some governors in Nigeria as the Supreme Court rules in 8 governorship election and races. Now, the thick tension which soaked the affected states suddenly dissolved and turned into celebration after the Supreme Court delivered its verdict in the governorship tussles in Kano, Plateau, Zamfara, Lagos, Bauchi, Abia, Ebonyi and Cross River states. This morning, I will be analyzing some of the judgments, especially in the cases of Plateau, Zamfara and Kano states, which received more public attention than others. And of course, we'll talk about the takeaway from the Apex Court judgment as Nigeria's democracy grows. We have in the studio a constitutional lawyer, Mr. Sam Kargbo. He is a senior advocate of Nigeria and has handled and won many electoral cases. Good morning and thank you for joining us this morning.
Thank you for having me.
Okay, so
very interesting take, isn't it? More often than not, people remember the ones you win, not the ones you lose.
Yeah. Exactly. So let's talk about your own take on the result, the verdict of the Supreme Court. Immediately you heard everything that was announced. What was your first reaction?
I saw it coming, and I think I've made a hint here that the first, second standards of those things are usually not much of a concern as what the Supreme Court would say. And I think I've also had to make that as a reason why people should not be too excited about what the decisions at the tribunal and the Court of Appeal, because the Supreme Court is the court of final instance, and the gentlemen there are a little bit much more seasoned, much more circumspect, and they have a better global view of the law than the other cadres of, or the other ranks of the judicial system. So usually when I see people getting too excited and making aspersions at the judicial, I say, oh no, wait a bit. You know, this is not a one-off thing. You know, this is actually a system that by itself, it makes sure that at the end of the day, everybody who follows it up sees that, yes, justice would, at the end of the day, be dispensed to the rightful party.
But you would agree with me that, Abdullah, you would agree with me that a lot of people had that much expectation of anything could happen during the election. But then there was this fear. Majority of people were tilting towards the retaining of the judgments of the tribunal and the appeal court, because out of the blue, it's like a shocker for people saying 2 courts are saying this, and then the Supreme Court is coming out to say this. Even the people, the winners of this verdict, also got shockers of their life.
You know, they have an influencing effect, especially when they look at what, if you have a very brilliant court of first instance, there is always that tendency for you to be carried away by their own reasoning. And most of the time to the Court of Appeal, especially for election matters, they don't have too much of a time to look at these things holistically and arrive at a different decision. But the Supreme Court usually takes its time, and by the time the matters come to the Supreme Court, they would have followed it up. And the moment they get the record of appeal, most times they sit on, they make their own conference, and from there they have their thoughts and they share their thoughts. And because they've always been the court of final decision, and because the judgments that are relied upon by the first and second tiers, that is the tribunal and the Court of Appeal, are theirs, they understand those cases much more than those who are relying on them. And because it is theirs, they know the ambit and the limits of those principles. So when cases come to them, it is no longer about you relying on the apex court's decision. This time around, it is the maker of the decision that is reflecting on it based on the facts before it. So they usually stand in a better position to arrive at the right decision. And most of the time, to have said it here, electoral cases are mathematical, and when I see a judgment, you ask me, I would have my doubts. But I wouldn't express it to say, oh, that's a wrong judgment. I would say, let's wait for what the Supreme Court would say. You know, like in the case of Kano, I have seen so many insinuations that as to say that the apex court was intimidated into making that decision. I can tell you for free, I have had to make the opinion, express the opinion over and over that I do not think those decisions would stand, you know, especially as regards the issues of non-stamping and all of that, because the vote is sacrosanct. For you to nullify a vote, you must have a very concrete reason for that. And most of the time, the law has excused the electoral officials to say where they failed to do this. You understand? They are excused because at the end of the day, as long as the result reflects the wishes of the people, all their mistakes or all their omissions should be excused. You cannot, on the basis of what? The inactions, the omissions, or failures of electoral officers nullify a vote. Because that would mean you yanking off what? The mandate of the people on the basis of technicality.
Yeah, but you do know, Mr. Sam, that there are governors in Nigeria today that are referred to, or rather, I think a governor that has been referred to as Supreme Court governor for obvious reasons, that he came fourth in the election, but somehow he ended up becoming governor after the Supreme Court verdict. That is just to stress the point that sometimes Nigerians have had cause to really worry about the input of the courts when it comes to elections, where the people's decision does not end up being the people's decision because it is, you know, the court override it. But the question I want to ask is, for Nigerians who are watching the program right now, how do you explain to them, if the law is in black and white about what the rules say, how do you explain the tribunal saying one thing, the appeal court doubling down on that same verdict, and then you have a Supreme Court saying, you know what, you don't know what you're saying. You're making a big mistake. That is an error. Because clearly, I mean, in simple terms, that's basically what they're saying.
That is as normal as normalcy can be. If you are a practicing lawyer, that is not something to talk about anyway. Because most of the time, you see, we lawyers, we are nearer to the facts. Is the law subjective? No, it's not subjective. Listen, we lawyers are nearer to the facts. We lawyers are the composers of the narrative of the cases that will present before the judex. You know, sometimes you would be emphasizing the point that this is the issue and this is my view on it. You, the lawyer, but the judge has his own views on it. Mind you, these are people we all wrote the same exams with. You understand? And we are all called to the bar, the same bar, and we read the same books, we read the same cases. But because he is sitting there as a judge, he has what? A commanding position over that case. But that does not mean he has the final say. After he would have made his own judgment, I would say, oh yes, thank you, brilliant judgment, but I'll go on appeal to re-emphasize what? My own argument, that if you had looked at it this way as I have actually envisioned it, the decision would have been different. The Court of Appeal might say, oh no, 3 of them, or sometimes 5, they could still agree. But you know that you are right. you still now go. I have had to do that many times. And when I get there, they vindicate me, and I come back and say, I was right.
Right, okay.
You were wrong. Because that's the way the process works.
So
now, coming back, so that we don't close on the over it. You see, the case of Imo State, the best case, you see, read the case, read the circumstances of that judgment so that you don't just think that the Supreme Court just whimsically gifted the, the governorship to Hopisodema. Mind you, the Supreme Court is blind to the facts, and is supposed to be blind to the fact the litigation is for the parties. If I bring my own case before you, you think that my case is frivolous, I do not make any effort to rebut or make a rebuttal. You understand? And I go ahead and prove my case. Mind you, when you go as a petitioner, you are not going to make second and third parties. You are number 4. You are not going to make second and third parties as parties. You go to make what? The person who won. That is the person who has the return, who has been declared a return. He's the person you are going to challenge. If that person now did not do his own homework, and I'm able to prove my case, and I got judgment, you shouldn't say, oh, because what? Second and third are there.
But senior
no, it is not the business of the...
Senior advocate, you just talked about the sanctity of the votes.
Yes.
Right?
Yes.
We just talked about the sanctity of the vote.
Yes.
And there is no way we can morally justify...
No, well, you say
based
morally.
on technicality.
Well, at the moment you say morally, I give up. Yes.
Yeah. But also, not morally. Even the spirit of the law itself.
Yeah.
Right?
Yes.
That judgment goes against the spirit of the law, because the law itself is supposed to be just and fair. And there's nothing just and fair in that particular technicality. I mean, I don't want us to really litigate the Imo situation.
No, justice and fairness for the lawyers is what? Procedural. It's a procedural thing. It is not a substantive thing that you say, this is Sam Kargbo. It's a person that is Sam Kargbo at all times. No, it's a procedural thing. That's the way we see it.
When it comes to processes, be fair and be just.
The outcome of that procedure, you understand, would actually transmit into justice as long as the parties who have come before the judges are given the fair hearing. Once both parties are given the same opportunities to espouse their own grievances and contest issues, and at the end of the day, one party has what? An upper hand over the other party, justice has been done.
I still think it defeats the purpose of democracy if just because of the technicality of the second runner-up and the third runner-up not being on the case, the fourth person gets to win because he took the case to court. I still think that there's a lot to be said about that.
To avoid that, perhaps we should go to the continental system. The continental system is not adversarial. The judge is not what? Independent, or the judge is not removed from the fray. He's part of the fray.
He gets into the battlefield.
He gets into the battlefield because what? He is both a finder of facts and a finder of law.
Perhaps we should experiment with that.
Until we get there, things are going to be like this.
Okay, but I asked that question because, you know, the whole black and white thing is that, you know, there are certain principles that don't change, regardless of how you look at it.
Definitely,
right?
definitely.
Say, for instance, in maths, 2 + 2 will always be 4, regardless of how you want to go about it.
That's
right. He said that's
mathematical measurements.
But also, when it comes to law, interpretation, for instance, which is the core responsibility of the judiciary. Explain to me the Plateau State situation, for instance. The whole National Assembly was swept away because of the same argument that Governor Muftuan survived in the Supreme Court. Make it make sense, where, you know, the same flood waters that took away the seats from the PDP at the National Assembly and State Assembly.
16 of them,
yeah, exactly. All of them gone. But the governor survived it. Explain to me how that is possible.
You see, for us to avoid that, you know, the idea that National Assembly cases should stop at the Court of Appeal those are not legal issues. Those are what I would call policy issues. And the idea is that the Supreme Court should not be overworked. Yes, that makes sense. But this sort of cases calls for what? A review. Mind you, before now, even the governorship elections, they stop at the Court of Appeal. But, you know, sometimes, for the sake of democracy and for the sake of that individual, because the entire essence of the law, the rule of law, constitutional law, is what? To ensure that the individual is what? Prevented or is protected from the harm from what? The majority or the rest of humanity. Is to protect you as an individual. That is what the law is about. And I would therefore, and I have had to say so, that irrespective of how expensive it is, how tedious it is, how torturous it is, let us find a way of standardizing this so that we don't have this sort of mishaps. Definitely, the electorals there would, for the rest of the 4 years, feel shortchanged. I have.
Should the people from the states now go?
No, they have no. You see, they have no other recourse and no other remedy, because what? The Court of Appeal is the court of final instance in the case of what? National Assembly election. I have had a case where a panel said, when somebody says you are not qualified, they say it's a negative assertion, and therefore it is you that should prove that you are qualified. And I was like,
so the burden of proof is no longer on the person.
It's no longer this. And I was like, seriously? When we were at the Supreme Court, then my junior colleague who went there sent me, what do you call it, a note, a WhatsApp note, that this is the decision. I say, it can't be. You are not listening to that. He said, that's what it is. But at the end of the day, that's what it is.
All right, so
I was perplexed, but I told the client that, what can we do? That is the court of final instance. They said, oh, what do we do? Can we go to the NJC? I said, you would have to prove what?
Yeah, but isn't there? Because at the end of the day, we're talking about justice and not just judgments, right? Because it has to also be, you know, those judgments or verdicts have to meet the letter and the spirit of the law, so that there is an alignment, isn't it?
Yes.
To Subi's point exactly, where is the recourse there? Because at the end of the day, people feel such a change. I mean, I beat you fair and square in the election. And the law says, listen, these are pre-election matters. They cannot determine, election matters now. And you go to the court and then they sit on a pre-election matter and nullify my election and give it to somebody. There has to be a course correction here, surely.
Tomorrow, that may come, but for now, none. And let me also say this. I've had to say so over and over. You see, there's a very thin line between pre-election matters and post-election matters. The very clear ones are issues of nominations. Those
qualification.
No, not qualification. Qualification too, we've had to battle it in so many ways that the line is still very thin. You understand? But issues of nomination, I would have thought that by now that had been solved. But because of the decisions coming from the Plateau jurisdictions, I would think that there should be a kind of a revisit of both the law itself and perhaps the issue of where the National Assembly cases should end. I would also want to make the proposition that we can still make use of retired justices of the Supreme Court. I can tell you for free, a 70-year-old man or a 75-year-old man is still very lucid and very calm and still can do the job. We see that happening in America. Why don't we get them involved in the election petition so that if the issue of overburdening the Supreme Court is what justifies National Assembly cases to stop at the Court of Appeal, we can have a kind of a middle of the road course whereby we now constitute a special panel of the Supreme Court for that purpose only. And that's special. No, to receive and treat appeals from the Court of Appeal. So that if we have any available and willing Supreme Court justice, we can. You understand? Get them involved. In other places, next door to us here, Cotonou and other places, they have constitutional courts. Those ones are purely for these matters, so that they do not interfere with the everyday court processes and matters. But now, we have all other matters standing still until they finish the election matters. And the cases are too many for one to think that even if you now want to say, let matters go to the Supreme Court, not with this number. They have just recently risen the number to 19. Even after that, it's still a very Herculean task for them to handle all of this. But for the sake of justice, like I said, for the sake of democracy, deepening democracy, I do not think that we can stop at any length to ensure that we prevent this sort of mishaps. Because these ones could be purely legal errors. Because you could go that route so very easily. And once there has been a decision, there is always that tendency for us to follow that decision so that what? You reinvent the wheel.
Son, 2027 it's coming, right?
Yes.
So it's just a matter of time. I mean, we're in 2024 now, so it's rushing. But then what do you think that this judgment would impact in the political landscape in Nigeria, considering we're seeing different judgments on different particular issues? And you made mention of a lot of things that could help that kind of situation. But what about the political landscape now? What do you think they need to do in order to avoid all of these things that happened in the first place?
Well, the politicians are the lawmakers. They are the lawmakers. You understand? The judiciary only act on the law. So I would think that the first response is for them to revisit the law, the electoral law, as bad as it is, because it's always been after every electoral session, they review the Electoral Act. But even after that, there is always this sort of cases coming up to give some new challenges. But that's the nature of man. That's the nature of the social and political process. It always throws up its new nuances and challenges. It is for them to react. Then now, for what has happened there, it's for the politicians to know that sometimes you win unfairly, sometimes you win. It is for them to talk to their people to say, hey, we've lost this. But all is not bad. We've gotten the governorship and we'll find a way. I have seen some reactions there. Somebody saying, I hope that is not true. The speaker saying he is what? A person non grata to all of the 16, more or less. That is going to wreak some havoc to the state because those ones are going to put a resistance. Because what? The law has given them what? A mandate.
Okay. Just before we go, very quickly.
Yes.
What do we do and what is the operational standard procedure here when judges give judgments like this? I mean, everybody in every sector, we have a performance review. Give me a sense of what the NGC does about some of these unfortunate verdicts that make Nigerians scratch their heads about whether that is in alignment with the idea of justice. I mean, do we review their performances? Are these judges, queried for giving some of these judgments? Because you realize that if you're going through the judgment of the Supreme Court, it's an indictment on the judge that gave, that particular, or the panel of judges that gave that particular verdict in the first place. So what are we doing about that so that we can improve the quality of the judgments going forward? Because if there is no recourse, so to say, they can do this over and over again because there's no,
I agree with you, that's an indictment, but you see, it's normal, except if you impute malice, that those judgments are actuated by malice or fraud. I wouldn't think so. I would not want to go that route. It could be an error. But the agency also reviews. Of course, they would have to sit again to have a kind of a review of the cases and be informed by that. But also, anybody who is at the Court of Appeal should be dreaming of going to the Supreme Court. And most of the time, what is taken into account is what? The soundness of your judgments. The soundness of your judgments. And that is why I strongly believe that those judgments may not have been actuated by malice or fraud. It is just an error. But those sort of errors also may not go into your favor, because when they ask you to submit your own judgment, I do not see you submitting a judgment that the Supreme Court has overturned. Right. You understand? So most of the time,
that's in the interest of self-preservation, they wouldn't want to do this naturally to themselves, if not in error. Because
they would not. Yeah, that's what I'm saying. They would not, because except if you are not ambitious. Right. But I would think that for you, as a lawyer who has been given the benefit and the opportunity to sit on the bench, your dream should be to go to what? The Supreme Court. Just like for us, the practitioners, the dream is for you to be a senior advocate.
All right. Thank you so much, Mr. Kargbo, Sam Kargbo, Senior Advocate of Nigeria. Thank you so much for joining us today.
Thank you very much.
To talk about these issues.
Thank you very much.
All right.